I would like to welcome you to Hinshaw's 25th Annual Labor and Employment Seminar. We have a great program planned for you today. No seminar provided by attorneys could take place without a legal disclaimer. The information presented today is not intended to and does not constitute legal advice, recommendations, or counseling under any circumstance. You should not act or rely on any information provided without seeking the advice of an attorney licensed to practice in your jurisdiction for your particular situation. In addition, the information presented during this session does not necessarily reflect the opinions of our clients. Again, thank you for joining us today. Let's get started. It's my great pleasure to welcome today's presenters, Amy Delaney and Lee Bonsall.
Thank you, Carrie, and thank you everybody for attending our annual seminar in virtual format this year. We know this is very different from what you're used to, and we normally love hosting all the attendees every year at a location, usually in the suburbs, but we all know 2020 is different. And so Lee and I are thrilled that you're joining us today. We've had the pleasure of bringing you the year in review for the past couple of years for our annual seminar. We have a window of your lunch hour today. We didn't want to dominate everybody's time too much, so we have a lot of information to share. But just a little bit of background on Lee and myself. We are both members of the Labor and Employment Practice Group at Hinshaw and Culbertson. Lee has been practicing in the field for 10 years. Myself, and we're excited to cram this in for our presentation, and aptly named 2020 Year in Review. Is it over yet? And so with that, I will kick it over to Lee for our case law update.
Hello, everyone. Thank you so much for being with us today. I will get us started with this year's Supreme Court decisions that had an impact for employers. The first one is the Bostock case, which is probably the most significant case out of the Supreme Court for employment law. Bostock is a trio of cases that reached the Supreme Court with the issue being whether Title VII's prohibition against discrimination based on sex extends to discrimination based on sexual orientation or gender identity. The Supreme Court held that Title VII does provide protection against discrimination based on sexual orientation or gender identity. So here in Illinois, those categories have already been protected by our state law, but the court's opinion is significant in that it extends that protection to the majority of states that previously did not ban sexual orientation or gender identity discrimination in their state civil rights laws. This next case, Our Lady of Guadalupe School versus Morrison Berry, is one that has to do with something called the ministerial exception. And this is an exception that comes out of Supreme Court precedent. It applies to religious institutions. It makes them exempt from anti-discrimination laws in regard to employees who are considered ministers. This is based on First Amendment protection for religious institutions. And really what the court is trying to do is stay out of employment decisions regarding those who hold important positions within churches or religious institutions. In this case, one of the plaintiffs was a teacher at a Catholic school who was asked to go from a full-time contract to a part-time contract, and then the next year did not have her contract renewed, and she filed an age discrimination claim. There was another teacher who also had a contract not renewed, and she claimed it was because she had taken a leave of absence for medical treatment. The school argued that these two teachers were barred from asserting their discrimination claims because they were ministers under this exception, even though they did not have the title of minister. The court held that to determine whether an employee is a minister for this exception to apply, the key consideration is what the employee actually does. In this case, the court held that educating young people in their faith, which was the responsibility of these two teachers, was at the very core of a private religious school's mission, and therefore the ministerial exception applied. So these teachers ultimately could not assert their employment discrimination claims. So the case is notable in that these were school teachers who also taught a variety of secular courses, and they were not titled ministers, but the court still allowed this exception to apply. Our next case is this Comcast case, which is a case about Section 1981. And Section 1981 applies to race discrimination claims that came out of the Civil Rights Act of 1866. It states that all persons have the right to make and enforce contracts. In this case, the facts were that Entertainment Studios Network, ESN, which is an African-American owned television network, sought to have Comcast carry its channels. Comcast refused, citing lack of programming demand, bandwidth constraints, and a preference for programming that ESN did not provide. ESN, along with the National Association of African American Owned Media, filed suit alleging that Comcast behavior violated Section 1981. The legal issue was whether a race discrimination claim under Section 1981 requires that the plaintiff show but-for causation. So that would be a showing that race was the reason for the alleged discriminatory action, or if it was sufficient to show that race was a motivating factor. I'm sure most of you are aware that under Title VII, a plaintiff can prove discrimination by showing that the protected characteristic was the motivating factor for the employment decision at issue. Title VII was amended in 1991 to include that motivating factor standard after the Supreme Court's Price Waterhouse case. However, in this case, under Section 1981, the court held that the plaintiff does bear the burden of showing that the plaintiff's race was the but-for cause for its injury, and that burden remains constant at all stages of the lawsuit. The plaintiff argued that the motivating factor test from Title VII should be applied to Section 1981 cases, and the court disagreed, explaining that the Supreme Court has already rejected these efforts twice, and that the motivating factor test was added to Title VII in 1991, and Congress also amended Section 1981 without mentioning motivating factor in its revised provisions.
To Lee's point, the important thing with that, just for employers, is just that it's a higher standard for plaintiffs, employees, or former employees to be able to meet the standard under 1981, which private employers can be sued under.
Mm-hmm. Yeah. And our next case actually dealt with a very similar causation standard, this time under the Age Discrimination and Employment Act. And it's actually even more specific than that. This case had to do with a provision in the ADEA that applies to federal government employees who are over 40. So this case involved a pharmacist at a VA hospital. She claimed she was denied training and passed over for promotions due to her age. And the issue was whether this provision under the ADEA that protects federal employees requires a plaintiff to prove that age was the but-for cause of the challenged personnel action. Here, the court held that the statute's language in this particular provision demands that personnel actions be untainted by any consideration of age. So based on that language, the court held that age need not be a but-for cause for an employment decision in order for there to be an ADEA violation in regard to these federal workers. The court's holding was that the motivating factor test applies rather than the but-for test for causation for federal workers. So in this context, the court is holding the federal government to a higher and stricter standard than private employers. Now we get to this Equal Pay Act case, which you might feel like you've been hearing about for a long time, and that's because it's got kind of an interesting procedural history where this was a Ninth Circuit opinion that then went to the Supreme Court and then was remanded because one of the Ninth Circuit appellate judges had passed away after the hearing on the case occurred, but prior to the opinion being issued. And ultimately what happened is the court pretty much ruled the same way the second time around when the case was before the court, the Ninth Circuit this year. This was a case that involved a female math consultant who was hired by the county and then learned that a male consultant hired at the same time was making more than her, and that actually all of her male counterparts were making more than her. The county's justification was that they based her pay on prior salary and that served as an affirmative defense to the Equal Pay Act claim. If we go over to the next slide, we've got the Ninth Circuit's decision, which maintained its prior holding and held that prior salary cannot be the sole justification to explain a pay difference. What's important to note for all of us who are in Illinois is that the Seventh Circuit still allows prior salary to be considered a legitimate factor other than sex to justify a pay discrepancy, and that can be asserted as an affirmative defense to an Equal Pay Act claim. But we should be very aware of this change in the law coming out of the Ninth Circuit because it could definitely make its way here. And then the final case I've got is actually a district court case, but it's a good one on religious accommodation. In this case, there was an applicant for an assistant manager position at Walmart. He was offered the job and then disclosed that he could not work on Saturdays due to his religion. This was a 24-hour Walmart where managers were required to work on Saturdays. Walmart withdrew the offer, but did offer him a non-managerial position, and the candidate then filed suit. So the applicable law here is that Title VII prohibits a prospective employer from refusing to hire an applicant in order to avoid accommodating a religious practice that could be accommodated without undue hardship. In this case, Walmart was successful in moving for summary judgment. The court held that Walmart's offer to the candidate for a different job was a reasonable accommodation, and that the candidate's request to not work Saturdays would have resulted in an undue hardship. So this is just a good case illustrating the scope of an employer's duty to accommodate, especially under facts like this, where the candidate disclosed the need for an accommodation right after receiving an offer. And then I'm just going to make note of one additional case that came out last week after we had made our slides. And I'm sure you saw it in the news, but this is the Uber case that came out of California. The California appellate court case held that Uber and Lyft need to reclassify their workers as employees and not as independent contractors. This was after Uber and Lyft had threatened to shut down operations in California following the trial court's ruling. So in terms of gig workers, this is a significant case and trend to be following, even though it's currently just in California. And they're also going to be voting on Prop 22 in California, which would allow these app-based drivers to be independent contractors. So it'll be interesting to follow what happens with that.
Okay, thank you, Lee. That brings us to federal paid leave and the FFCRA. And I am sure for those of you that work within human resources of your organization or are responsible for managing benefits, that you are up to your eyeballs in FFCRA webinars, issues, but we certainly couldn't have a 2020 year in review without covering this significant development for the year. Lee and I were also commenting that, you know, generally speaking, you have had other years that had more developments, harder to manage, a lot more changes, particularly the amount of laws that were passed in Illinois with employment implications in 2019 and 2018, more so than you've had this year. So good news, take a breath. The difference is that you had this significant development drop on you on April 1 and had zero notice it was coming, zero, you had about 2 or 3 weeks to prepare for it, to understand what the requirements might be, but operate very much in the blind. And so I think that's what made this more challenging for employers in terms of a new development to try to comply with, because even though it's, two things, emergency paid sick leave and expanded FMLA, it came without a lot of notice, obviously, because the pandemic didn't have any notice, and everybody was really trying to learn and figure this out at the same time, including the lawmakers that passed it and the agency, the Department of Labor, tasked with enforcing it. So a brief overview for you, and then really some updates to make sure that you're aware of changes that took place in September. So the brief overview, because I know you are all experts on this, having managed it since it went into effect on April 1, is that the Families First Coronavirus Response Act had 2 elements of federal paid leave. There's the shorter 2-week emergency paid sick leave and the much longer, up to a total of 12 weeks, emergency FMLA. They are different not only in that sense for the amount of time that the leave provided, but the grounds for which an employee may qualify for the leave. The emergency paid sick leave has 6 total grounds of eligibility. The emergency FMLA has just 1 reason that somebody may qualify for that leave. And that 1 reason is associated with the inability to work because of the need to care for a child whose school has closed or childcare is unavailable due to COVID. So that is the only reason for the emergency FMLA. That reason, and this is where things can sometimes get confusing in the administration, is also one of the 6 reasons that an employee may qualify for the 2 weeks of paid sick leave. The leave for emergency FMLA is only at 2/3 of the employee's rate of pay. For the emergency paid sick leave, it varies by the reason that the employee is qualifying for the leave. 3 of those reasons qualify for full pay, and the other 3 qualify for 2/3 pay as well. And there are caps that are in place for both of those leaves. So highly compensated employees may implicate those caps more so than lower paid employees. On the Emergency Family Medical Leave Expansion Act, the Emergency FMLA, same effective period as the paid sick leave. So right now, unless and until another stimulus package changes this, the rights under the federal paid leave go to December 31, 2020. There's been lots of proposals made for new stimulus packages that might extend that, but without any agreement in that regard, the expiration date looms here for December 31, 2020. This one does have a trigger that the employee has to be employed with you for 30 days before they're eligible to qualify for this leave. And as most of you are well aware, this applies to all employers with fewer than 500 employees. That is also the same for the Emergency Paid Sick Leave Act. A covered employer is any employer with less than 500 employees. The same period here that the statute's in effect, April 2nd to December 31, unless and until we get an extension under a new stimulus package. This does not have the requirement that an employee be employed with you for at least 30 days. So this would apply to even newly hired employees. Common question, is my business subject to the FFCRA? And really all employers that have less than 500 employees are covered by these federal paid leave provisions. There are 2 exceptions to where benefits might be exempted or excluded. One is if your employees, and we're going to talk about that, fall within the healthcare provider exemption, you may not, even though you're under 500 employees, have to provide benefits to an employee. Or secondly, the small business exemption, which is less than 50 employees. However, you know, we have to think about lots of people initially when this came out thought, oh great, I'm less than 50 employees, I'm not going to have to comply with this. The small business exemption is not that broad, as you will see. If you have less than 50 employees, can you deny all FFCRA leave requests? No is the answer to that question. The small business exemption, assuming you can meet it, only applies when an employee is seeking leave for the grounds associated with the need to care for a child because the school or daycare closure due to COVID. That's the only grounds for leave that triggers a potential small business exemption. However, if you are under 50 employees and you have an employee or employees who are seeking leave under that ground, you may be eligible for the small business exemption. I've given you the statute, the regulation provision here that really details how you have to satisfy that small business exemption. That is also here on the next slide for you. There are 2 important points associated with this. You have to document that a determination has been made pursuant to these 3 criteria and retain that documentation. And regardless of whether you actually qualify for the small business exemption, which again only allows an exemption when that one category of leave is being sought, you still have to post the notice that the statute requires. There's a notice requirement to post alerting your employees to the federal paid leave rights. So in order for you to qualify for the small business exemption, you have to meet one of these 3 bullet points here and be able to document that you meet these bullet points. They're not super easy, but at least it will give you a sense of, if you think you have the ability to qualify, what you have to do. The Department of Labor has confirmed for us that they do not want you sending the documentation into the Department of Labor, but it's something that you should maintain so that if you ever faced a challenge on it, you would be able to show that you meet that exemption. So what's the big development? Because you're all such experts on the FFCRA leave, which, don't forget, it seems very intimidating as an employer that you have an obligation to provide paid leave. You get all of that back in tax credits. And so if you're not versed on how to do that, you should confer with your accounting staff, anybody that helps you with taxes for the organization, or speak to an employee benefits attorney who can also help you navigate how to get those tax credits so that that money is returned to you. But one of the biggest development that we wanted to alert you to today while we have you is the impact to the FFCRA rights and regulations by virtue of a lawsuit that was filed in the state of New York. So the state of New York filed suit against the U.S. Department of Labor shortly after the regulations came out and went into effect in April of this year. They were challenging 4 specific parts of the regulations that were contained in the Department of Labor's regulations that the state of New York felt the department exceeded its authority. So the Congress passed the Families First Coronavirus Act. It had the statutory provisions, but within those provisions, it said that the Department of Labor would have the authority to pass regulations. The Department of Labor passed regulations that spoke to a lot of different enforcement details of the federal paid leave rights, some of which were pretty significant limitations for employers, benefiting employers on those rights. And so the state of New York was challenging those restrictions. One was is referred to as the work availability requirement. We're going to take a look at these in more detail. 2 was the definition of healthcare provider. 3 was requiring the employer's agreement before this leave could be taken intermittently. And 4, associated with the documentation requirement and the Department of Labor's regulations, which required an employee to turn that paperwork in before taking the leave. So what was the work availability requirement that was challenged in the suit and won, by the way? The state of New York won its suit. This was decided fairly quickly on summary judgment. The decision came out, I believe, in August. And so the Department of Labor had to scramble. We had this period of time where we didn't quite know what the consequence of that decision was once the state of New York was successful. And so work availability, as originally put out by the Department of Labor in its regulations, said that, you're going to get federal paid leave under either provision of the 2 weeks or the expanded FMLA for those who are unable to work or telework due to one of the enumerated COVID reasons. Employees who weren't working because their employer didn't have work for them were not eligible to obtain leave. This was contained within the Department of Labor FAQs, and it was also then put in the Department of Labor regulations. When this got thrown out, the big question was, okay, wait a minute. So does an employer have to provide paid leave to an employee who is not working because we're on furlough, or who is not working because they're on temporary layoff, because we're in an industry where our businesses have been closed? I have to provide paid leave for them, even though there's no work available for them to do. That was the sort of limbo we were in following that New York decision. However, the Department of Labor reissued its regulations addressing the New York suit. These regulations went into effect on September 16th, 2020. The Department of Labor is absolutely standing by its work availability rule as originally contemplated in the regulations, with some modifications to address the lawsuit. So number 1, it applies to all 6 of the eligibility grounds for leave, not just some. So that helps to bolster it. It also addressed the concern that the lawsuit had in terms of how this could be taken advantage of, and provided a better rationale for why work availability should be required. So the good news for employers is that the Department of Labor is standing by that, reissuing it in its regulations, means that that should still be something that is a threshold requirement for eligibility, that this is not an employee that's on layoff. It's not an employee that's on a temporary furlough, for example. And they built in the rationale that the court thought that they were missing, which is what justified the regulations being struck down to begin with. The caution here from the Department of Labor in reissuing the work availability requirement is that this is not something employers can use to try to keep employees from being eligible for the work. It's not a day-to-day determination. It's not, oh my gosh, if Amy showed up today, would we have work for her to do? The requirement should be understood in the context of those anti-retaliation provisions, so that you're not playing games with an employee who would otherwise be eligible. The other aspect of the Department of Labor regulations, which was thrown out by the New York decision and which the Department of Labor has attempted to correct in its new regulations, is the definition of healthcare provider. And so for those of you who are, those employers who are hospitals, doctors' offices, clinics, other, kind of traditionally thought of, I guess, healthcare providers, might be nursing homes, care facilities. If you have been using this exclusion, this exception under the Department of Labor regulations to exempt employees from being eligible for leave, you need to be familiar with this revised definition issued by the Department of Labor. Under the original regulations, it was very broad. The Department of Labor said, hey, employers, you can exclude anybody that's considered a healthcare provider from the benefit rights under these statutes. And a healthcare provider was going to be seen as anyone employed at a hospital, a nursing facility, a retirement facility, a nursing home, and I've got the rest of the original language from the regulations for you on the screen. It was viewed not from the function of what the employee did as a healthcare provider, but who they worked for and the type of facility that they worked for. So conceivably, your IT employed in a hospital setting could have been excluded. That has been much more narrowed. The Department of Labor, in responding to the criticism of the New York decision, adopted a much narrower definition of healthcare provider. And that definition is now an employee who is capable of providing healthcare services, who is employed to provide diagnostic services, preventative services, treatment services, or other services that are integrated with and necessary to the provision of patient care. This is much more focused on what the actual employee does in terms of duties, as opposed to the type of facility that that employee is employed by. I also want to point you to the fact that these categories, are they employed to provide diagnostic services, preventative services, or treatment services, or other services integrated and necessary for care? These are further defined in the regulations. And so if you've been using that, you definitely want to take a look at those, have your human resources consult with those new provisions, and consult your labor and employment attorney. It is no longer enough that an employee simply be employed by that entity, right? And so this was intended to, your IT staff, even if you're a hospital, should not be somebody that is included in the exemption and denied benefits. People who are not in care, direct care positions. The definition of healthcare provider under the FMLA will count as well, which was very narrow to, licensed doctors, nurse practitioners, nurses, those sorts of things are covered as well. If you're trying to get beyond those types of literal positions, you need to be very careful here how you administer that exemption. Another interesting point from the Department of Labor, so the original regulations said, first of all, intermittent leave is limited. You cannot use it for all types of federal paid leave. The New York decision upheld that aspect of the Department of Labor regulations, so it was okay for the Department of Labor to pick and choose when intermittent leave could be used. The lawsuit, however, throughout, and the court decision throughout, the Department of Labor's position that you had to get the employer's approval before you could use intermittent leave. The Department of Labor revised regulations have come back and, like work availability, have stood strong on their position that an employee still require employer approval, and it further bolsters the rationale and support from the original FMLA language on when employer permission is required. And so they are standing by and reissued the regulations to affirm that you would need employer approval in order to take intermittent leave where intermittent leave will be allowed. And here's an important caution to pay attention to that the regulations note. Where you have a school plan that is on a hybrid plan, where either, there are certain days that the school is closed and other days that it's open, but those mandatory remote days are the school being closed. It's not the parent choosing remote learning on that day. That is not considered intermittent use. And so this can get tricky. Consult with the regulations, consult with your counsel. Where there's a hybrid plan, the employee should be allowed the leave under the FFCRA, and this is not requiring employer approval. The Department of Labor does not view a hybrid plan as something that triggers an intermittent leave need, but something that on each day that school is closed allows the employee the eligibility grounds for the leave, not triggering the intermittent aspect. The last element here was the notice requirement. So the FFCRA for both provisions permits employers to require employees to follow reasonable notice procedures to continue to receive paid sick leave. The inconsistency here between the original regulations and the statute that got struck down by the New York court was that the regulations said that the employee had to provide the information prior to taking the leave, despite the fact that within the statute language itself, it allowed for, only notice as soon as practicable and not creating an obstacle that the employee could be on the leave or trigger the leave and then have to turn the notice in. So there was an inconsistency there that was struck down. The Department of Labor recognized that, and so it clarified its regulations that the documentation doesn't have to be given prior to the leave, but may be given as soon as practicable. So be careful here, employers. If you are relying on some procedures you've put in place to mandate that all the required documentation or forms be filled out in advance of being eligible for the leave, you want to be careful on sticking to and enforcing a hard timing requirement, because that would be inconsistent now with the updated regulations. Our first CLE code announcement numbers are 66.
Okay, I am now going to take us through an EEOC update because the EEOC has been issuing some significant guidance this year. I am going to first talk about opioid use and accommodating that, and then I'll talk about some updated COVID guidance. So in regard to opioid use, the EEOC issued guidance indicating that employers who are dealing with opioid use in the workplace have the right to assess whether the use is pursuant to a prescription or a medically assisted treatment program, or if it's unlawful use. And unlawful use would include taking prescription medications when they're not needed, so things like codeine and oxycodone. In terms of an employer's accommodation obligations, an opioid addiction is itself a diagnosable medical condition that can be an ADA disability that would trigger those accommodation requirements. There may also be employees who are lawfully taking opioids pursuant to a prescription, and they would also be entitled to an accommodation so long as it does not pose a significant cost or unreasonable burden on the operations of the employer. Assuming an individual has a history of opioid use or is presently lawfully taking opioids, reasonable accommodations that an employer may need to offer would include different break or work schedules, changes in shift assignment, transfer to another position, or even temporary leave with job protection. This accommodation requirement would extend to an employee participating in a medically assisted treatment program if the employee has a history of opioid use and is not currently using the drugs unlawfully. An interesting point here is that while typically medical issues that are transitory or temporary are not qualified as disabilities under the ADA, this guidance suggests that a medical condition does not need to be permanent or stop an individual from working to become an ADA disability. And this takes into account that many conditions that cause significant pain and prompt doctors to prescribe opioids are going to be temporary in nature. And then a final point that's important is that as an employer does not have a duty to accommodate if the employee is currently using opioids illegally, and employers retain the right to terminate employees for the unlawful use of opioids. Switching over to some COVID guidance, the EEOC's guidance states that temperature checks and maintaining a log of checks are permissible practices for an employer. Also, monitoring for COVID-19 symptoms and for exposure to COVID-19 symptoms is permissible, and requiring an employee to stay home because they're symptomatic or they've been potentially exposed to COVID. These are all permissible things under the EEOC's COVID guidance. And what we would suggest as a best practice is to have a COVID policy in place, provide notice to employees that this information is going to be collected. The EEOC's guidance also provides that COVID testing is considered job-related and consistent with business necessities, so that it is a permitted medical exam under the ADA, whereas antibody testing is not, and that's because it's not going to show if the employee presently has COVID, so it's not considered to be a business necessity, and it would not be a permissible medical exam. So keep in mind that important distinction. And then just a couple of points not to lose sight of when you're balancing ADA compliance with COVID concerns. One of them is that any logs that are maintained of temperature checks or COVID tests, those are considered confidential health records under the ADA, so they must be handled according to those rules. And then also an employer still has all of its anti-discrimination responsibilities and its responsibility to reasonably accommodate disabilities. So under COVID, there may be accommodation requirements that arise if an employee has a disability that would make COVID exposure more dangerous, or if employees are experiencing things like stress or anxiety. And really, it would be the same accommodation framework that's used in any other any other context. You would go through the interactive process and evaluate the accommodations that the employee is seeking.
With that, we will move it to a Department of Labor update, because how could we have a year in review, of course, without a Department of Labor update? Couple things, and you know, it's kind of nice, I think, sometimes to have non-COVID related things, though, you know, it keeps us on our toes. The Department of Labor issued new FMLA forms this summer. So they updated the forms effective July of this year, 2020. We're providing you with a link where you can easily access those new forms. The forms remain optional, but you know, when you use the Department of Labor forms, you're better ensuring, right, that you're only including or seeking information that we're entitled to. And it also guarantees that you're communicating the information that the Department of Labor wants us to the employees. So it's always a good idea, I think, to use the Department of Labor forms, but if you have your own, take a look and you can see if the updates need to be incorporated in your own if you're not using the Department of Labor forms, or you are, but you need to make sure you're using the updated ones. The changes are primarily to the notice of eligibility and rights and responsibilities form, the designation notice, and the certification for the healthcare provider. The background on this is that in 2019, the Department of Labor sought comments on modifications to the forms, and these forms now are based on that feedback that they received from that soliciting the comments. They're electronically fillable PDFs. They can be saved electronically. You can, and as I mentioned, you can continue to use your same forms. You just want to make sure that they're tracking what the Department of Labor has revised. Their goal, I think, was to eliminate some of the guesswork and open-ended things that, particularly like the certification form, had required of healthcare providers. So you may notice some of that. The Department of Labor has also issued new proposed regulations for independent contractors. I feel like every year between regulations from the NLRB or the Department of Labor, it's either independent contractor, joint employer, right? We're in this constant updating of those proposals. And so here we are, Department of Labor has got some new regulations for independent contractors. These will sound familiar to you. I think they're part of the tests that have always been used, but focusing really on what the core concept is, the 2 points there, the nature and degree of the control over the work, no surprise, and the worker's opportunity for profit and loss based on initiative and or investment. And what does that always mean? We wrestle with that category a lot. You know, if you're the only person that this contractor's worked with, and it's, you know, it's almost a near permanent job, and they're not, you know, at risk of, you know, sort of having other clients, needing to get other income stream, you know, it's looking like sort of a full-time gig with you that is less than independent contractor. But just so you keep these in mind, if you are in your operations, you do rely or utilize in your structure independent contractors, subcontractors, you're going to want to pay attention to these new proposed regulations and double check that you're on the right side still and the individual is properly classified. We also got an update from the Department of Labor in an opinion letter on the application of the fluctuating work week. So this is something that maybe not a lot of employers utilize. If you do utilize the fluctuating work week, and keep in mind, this is something that employers can do in assessing whether an employee would be eligible or owed overtime, right? And so when their hours fluctuate week to week, you can utilize the fluctuating work week standard to assess whether overtime would be paid. And so here in an opinion letter, it was just to clarify that the hours don't need to necessarily fluctuate above and below 40 hours each week in order to be able to use the fluctuating hours model. It's kind of complicated. Like I said, not a lot of employers use it. If you do, let's be aware that this opinion letter issued and make sure that you're aware of it and how it might impact your analysis of how to use it. Perhaps most critical, I think, of the Department of Labor updates for employers, because this is most universally applicable, was the increase that went into effect for the threshold salary for the exemptions on the salary basis test. You know that for any employer that relies on your employees being exempt and they're meeting what we call the white collar exemptions, what goes along with those exemptions is not just the duty test. It's not just to show that they're actually, you know, substantively meeting the duties test of either, you know, the executive or the learned professional or the, you know, high-level administrative exemption. With those exemptions also come the salary basis test. So they have to meet the duties and they also have to meet the salary basis test. And that salary basis meant that they had to be earning a much lower salary. It was like $355 a week for an annual salary of something like $24,000. That has gone up. And so make sure your exempt employees are making this minimum threshold salary to meet the salary basis test. It went up to the equivalent of $684 a week, or an annual salary of $35,568. I always round up to $36,000 just to be safe, so you're not cutting it so close. If you're not, you need to reassess whether the position should be reclassified as non-exempt or increase that employee's salary. The highly compensated employee exemption went up to $107,432 a year. So again, this is something that probably many of you were aware of, but it went into effect in January 1 of this year. So it's a pretty important announcement. The second CLE code announcement is 8.7. And with that, I will turn it over to Lee again for the NLRB update.
Okay, so we are lucky this year because we get a new independent contractor test and a new joint employment rule. This was issued by the NLRB on February 26, 2020, effective April 27th. And what this rule does is it does away with the Browning-Ferris standard that came from the board under the Obama administration. Under that standard, the board held that for joint employment to exist, indirect control or unexercised contractually reserved control alone could be enough to establish that an entity was a joint employer. And that board ruling did away with years and years of NLRB precedent. So this new rule that came out aligns with the past board precedent prior to that Browning-Ferris decision. And now what the rule says is that in order for there to be joint employment, a business must possess and exercise such substantial, direct, and immediate control over one or more essential terms and conditions of employment of another employer's employees as would warrant a finding that the business meaningfully affects matters relating to the employment relationship. So really what's significant is that the standard now is that the putative joint employer must have this direct control. And why this joint employment standard under the NLRA is significant is because if two entities are found to be joint employers, both of those entities must bargain with the union that represents the jointly employed employees. Both are potentially liable for unfair labor practices, and both are subject to union picketing or other economic pressure if there's a labor dispute. So the NLRB's intent here was to restore this prior direct control standard and also to make that standard more clear.
With that, and in our remaining time here, we're going to cover Illinois updates for you. I also want to just caution, we're going to try to do our best in the last sort of less than 10 minutes that we have I see some questions popping up in the chat. If we can't get to those, we're going to kick them over to the Advice on Tap on Friday, but we'll be sure to get your questions answered one way or the other with that. So just keep that in mind here. Illinois updates for you. So again, while we have this wonderful captive audience, to remind you, July 1 always brings the minimum wage updates here in Illinois, depending on your location. If you're in Chicago or Cook County, we have a higher minimum wage than the state, but I've got all three for you on the screen here between what went into effect July 1 at all three levels. The state, which went to a $10 an increase, and you're going to get another one come July for the state. I'm sorry, January of 2021 for the state. And the city and the Cook are always on July of every year. The state increase will always be on January 1, but because this was the first year, they set an immediate increase to take place 6 months after the increase would take effect. So that's why you have a July increase here for the state as well. These are something to be aware of if you have employees that don't just commute in or around Chicago, but actually spend some period of time working, even if your operations are outside. And the city of Chicago or Cook County provisions will depend on, whether you're considered to have a business facility in the relevant jurisdiction. I will also throw out that Cook County's is only applicable in those jurisdictions that did not opt out of the minimum wage. So, and there's, kind of a a very long list of towns that actually opted out. So it may not be as impactful because you may be in towns that you know opted out of it. Wage and hour considerations to think of, as Lee covered all of those things that we can be doing with employees that the EEOC says we can do in terms of monitoring symptoms, mandating temperature checks. If we're requiring employees to do certain things, we all have to be thinking about whether that is compensable time. And so are our employees required to show up and stand in a line to get their temperature taken before they punch in? Are our employees required to complete a questionnaire that takes some significant time and turn it into a particular location before they're allowed to clock in? Be thinking of these things and the implications on the wage and hour standpoint. Maybe the time spent doing this is so de minimis that it shouldn't trigger a wage and hour implication for you, but you want to at least be considering it. Local public health orders is one of our last state-specific updates for you. We have a Chicago public health order, as I'm sure many of you know, that went into effect because we hear about it in the news every Tuesday when a state is in danger of getting put on the Chicago list. I have included here for you the link to the website that lists the current hot zone states, so to speak, and also identifies those that are on the verge of being put on. And this comes out every Tuesday. The list gets updated, and if a state gets added or removed, it goes into effect the Friday after the Tuesday that it was updated. By now, I feel like virtually every state except for Illinois is on the list, but check it and see. I think our stats are going up so much, we would almost be violating the Chicago order. So I'm not sure what you can practically do with some of these things anymore, but it's good to know because you may have an employee that is subject to this. And so it requires all persons entering Chicago from either the hot zone state, or we'll take a look at a Chicago resident who is returning to Chicago from travel to a hot zone state, to mandatory self-quarantine for 14 days. The duty is on the individual to do this. It's not our responsibility as the employer to make sure employees are complying with this order. It's all written to the individual. Anybody found in violation of it could be subject to a fine. I will tell you that when this first came out, the head of the Chicago Public Health Department noted that the real intent here was not that they were going to be independently going out and looking for violators, but as they contact traced outbreaks and contact traced to see, when cases were being reported, if they found that people had violated the order, that's how they would impose the fines, not, through some outward facing aggressive attempt to sort of independently find violators. There are FAQs that go with this public health order. I think they're worth reading so that you understand, because there's very little information in the order itself. The FAQs confirm that this applies to residents of Chicago. So those residents of Chicago who would travel outside to a hot zone state are subject to this and would have to quarantine. So if you have employees, you may not be in Chicago, you may not be subject to this order, but you may be employing individuals who are subject to it. And if an employee is required to quarantine with this, the caution I have for you are the FFCRA implications, because this is a local quarantine order that would trigger one of the eligibility grounds for the 2 weeks of paid sick leave to the extent you have an employee that is subject to this. Keep in mind, we had a lot of confusion over the essential workers exemption. People initially thought that, oh, if I'm an essential worker, this doesn't apply to me. And that's not exactly how the essential worker exception applies. What this is intended to do is, if you are a non-resident of Chicago, so think somebody that lives in Indiana, for example, who's now been put on our list or was on the verge of, you work in Chicago, but you live in Indiana, which is a hot zone state, but you have to come in and out of Chicago for work. That's somebody that this exception would apply to. If you are a resident of Chicago returning from a hot zone state that you had to go to for work purposes, that exemption would also apply to you. But if you're an essential worker, let's say you're a nurse who works at a hospital in Chicago, you cannot, but you traveled to a hot zone state for a vacation, that's not triggering this. So just be wary of this from an enforcement standpoint. If you're an employer who ends up with an employee who might have to quarantine for this purpose, particularly for the FFCRA implications. There is an anti-retaliation ordinance that was passed with this. However, I will tell you that this really relates to an employer has to be, a Chicago employer. You have to have a business facility within the geographic boundaries of the city. So if that's not you, you shouldn't have to worry so much about the anti-retaliation ordinance. And I think we're having some technical difficulties here. Let's see if I can get you, but this actually will wrap up our presentation. We've reached the end mark here for you actually. And so I'll try to share this again with you. But I know that we ultimately wanted to keep you within the 1 year mark. Just to follow up on the local sick leave ordinances, which was our last part here, that Cook County also adopted that. It's just a recommendation though. It didn't actually come in as an official order. So just something to keep in mind for the Cook County folks. And Skokie and Evanston were excluded from that because they have their own public health departments. So we have bumped up against our hour here, and I know we were really wanting to keep you all close in time for your hour lunch time commitment. We will make sure we get these over to the Advice on Tap session. If you are not able to make the Advice on Tap session on Friday, what we'll do is take these questions and we will get back to you. So I want to make sure that you have that. If you want to reach out to us directly as well, please feel free. You can email either Lee or myself, and we're at hinshawlaw.com. I wanted to thank you very much today for attending today's presentation, having the patience for the hour here and getting the updates.